Lieu put 2 photos in front of Bondi, then proved the investigation she closed was wrong. The first photo showed Prince Andrew, not a file photo, not a press image. A photograph from Jeffrey Epstein's world, an image documenting Prince Andrew's presence at a gathering connected to Epstein's operation. Next to the prince, a face. The face of a young woman whose identity had been redacted from the public release of the Epstein files because the law Congress passed required exactly that, the protection of victim identifying information, REP. Ted Lieu had 2 of these photographs. He held them up in the hearing room and asked Pam Bondi a question she had already answered without realizing it. He said, "You redacted the victim's face because you were following congressional law, correct?" Bondi said yes. And Lieu said, "You have now established that we are looking at a sex trafficking victim." That sequence, the confirmation, the acknowledgement, the pivot to what the acknowledgement meant, is the technique of a former federal prosecutor who has just secured the admission that makes the next question impossible to deflect. Bondi had confirmed that the redaction was made to protect a victim. A victim means a crime. A crime means a perpetrator, and the person standing next to the victim in the photograph, the person whose identity had not been redacted, was a specific named individual who was, under the Federal Victims Trafficking Protection Act, potentially guilty of a crime, not just Epstein. Anyone who patronizes Epstein's sex operation is guilty of a crime. That is not Lieu's characterization. That is the statute. And Lieu read it in that room because the photographs he was holding made the statute directly applicable to a named identifiable person. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Let's examine the photograph strategy before we get to the document. Lieu did not open with Trump. He opened with Prince Andrew. That choice was deliberate, and its logic becomes visible when the sequence is examined. Andrew is a significant figure in the Epstein case. His documented association with Epstein and Maxwell has been the subject of legal proceedings in the United Kingdom and civil litigation in the United States. His presence in the photographs is well documented and publicly reported. But Andrew is not the American president. He is not the person whose name dominates the Epstein file disclosure dispute. He is not the figure around whom the most politically charged questions in the investigation revolve. He is in the architecture of Lieu's argument, the test case. By starting with Andrew, Lieu was establishing a principle before applying it to the more politically charged name. The principle, photographs of an individual in the context of Epstein's operation, alongside a redacted victim, constitute evidence of a crime under the Federal Victims Trafficking Protection Act. He needed Bondi to confirm the redaction protocol, to acknowledge that the victim's face was redacted because the person depicted was a victim, before the principle could be applied. And he needed to establish that principle with a less contested figure before he applied it to the one whose name the entire debate has been circling. He got Bondi to confirm the redaction protocol first. The victim's face was redacted. That means there is a victim in the photograph. A victim in a photograph taken in the context of Epstein's operation, standing next to a named individual, satisfies the evidentiary threshold for opening an investigation under the applicable statute. Lieu established that principle with Andrew. He then applied it to Trump. The structure is the structure of a cross-examination. You build the premise before you apply it. You get the acknowledgement before you ask the question the acknowledgement makes inevitable. And you do it in that order because the person you are questioning cannot object to the premise after they have confirmed it. Lieu was a federal prosecutor before he entered Congress. That background was visible in every element of the approach he used in that hearing room, not in the form of legal arguments addressed to a jury, in the form of a documented, step-by-step evidentiary construction that arrived at a conclusion the witness had inadvertently helped build. He got Bondi to establish that victims are depicted in the photographs. He got Bondi to establish that the redaction was legally required to protect those victims. He established the statute that makes the patronization of Epstein's operation a crime. And then he applied all 3 elements to a named individual and asked why the investigation had been closed. Every step in that construction had been confirmed before it was used. That is how cross-examinations work. You do not ask the question until the answer is no longer available. Now, let's talk about the July 2025 memo. It is the document that the photographs sit against. It is the official statement of the Department of Justice's conclusion about whether there was sufficient evidence to pursue uncharged individuals connected to the Epstein investigation. It is the institutional declaration that closed the case. And it was issued by the same department that had the photographs in its files, had the witness statement in its files, and had never interviewed the person who filed that statement. In July of last year, the Department of Justice issued a memorandum. The memo stated that the DOJ had not uncovered evidence that could predicate an investigation against uncharged third parties connected to the Epstein case. The investigation, the memo said, was closed. Lieu had the memo. He read the relevant language into the record. We did not uncover evidence that could predicate an investigation against uncharged third parties. Then he put the two photographs back on the screen. The memo said, no evidence. The photographs were evidence. Both were in the room at the same time. The photographs are evidence. That is not Lieu's legal opinion. That is the logic he had established by having Bondi confirm the redaction protocol. The victim's face is redacted because the person depicted is a victim. A victim depicted in a photograph with a named individual in the context of Epstein's operation is evidence of a crime under the Federal Victims Trafficking Protection Act. The photographs exist. The evidence exists. The July 2025 memo said no evidence existed that could predicate an investigation. Lieu asked, why did you shut down this investigation last July? And why have you not prosecuted former Prince Andrew? Bondi said she didn't believe Lieu had asked Merrick Garland those questions when Garland was Attorney General. The room registered that answer, not because it was factually wrong. Lieu may or may not have asked Garland the same questions, but because of what it was instead of an answer. It was a deflection to a predecessor, a redirect to the failures of the people who held the job before Bondi. A move that every Attorney General in this particular history has available to them because the failures of the Epstein investigation predate every current official and can always be cited as context. Lieu said, I agree with you. He said it 3 times. I agree with you. I agree with you. I agree with you. That repetition was deliberate, not for rhetorical effect, because the deflection to prior administrations only works if the person being deflected to disputes the premise. Lieu was not disputing the premise. He was removing the deflection's utility by granting everything it asserted. Yes, Garland dropped the ball. Yes, Barr dropped the ball. Yes, Acosta dropped the ball. Every Attorney General who had this case before Bondi is acknowledged as having failed the accountability standard it required. All of that is granted. None of it is in dispute. What is also not in dispute is the current institutional reality. But you are in charge now. That is the sentence that the deflection could not survive. Not a contradiction, not a counterargument. A simple statement of the current institutional reality. Every prior failure is acknowledged. Every prior Attorney General's inadequacy is granted. And the person sitting at the witness table is the Attorney General today. She has the power that Garland and Barr and Acosta had. She can do what they did not do. She has the photographs. She has the statute. She has the evidence. The prior failures are not an explanation for continued inaction. They are a baseline that she has the authority to move beyond. And you're doing the opposite, Lieu said. You're protecting them. The room's attention sharpened at that characterization. Protecting them is a specific accusation, not a general criticism of institutional inaction, not an acknowledgement that prior failures continue, an active accusation that the current Attorney General's decisions are functionally protecting the specific men whose accountability is at issue. Lieu said it directly, building on the established sequence. The photographs constitute evidence. The statute makes the conduct criminal. The investigation was closed. The photographs still exist. Bondi began to respond. Lieu said he wanted to move to another question. She asked, can I answer about Donald Trump? He said, I want to move on. The exchange about whether she could answer before he moved on lasted a moment and produced something worth noting. Bondi's unsolicited introduction of Trump's name before the question about Trump had been asked is in the transcript. She invoked Trump before Lieu did in that specific moment. She offered to address Trump before Lieu had asked about Trump. That sequence is in the record. It does not prove anything about the merits of the questions that followed, but it documents that Bondi introduced the subject before Lieu reached it. Then Lieu showed the video. The principle had been established with Andrew. Now he applied it to the other name. Like former Prince Andrew, Donald Trump attended various parties with Jeffrey Epstein. The video documentation of Trump's social presence at events connected to Epstein's operation is part of the publicly available record. Lieu played it. Then he asked the question that the photographs in the video and the established principle about victims and evidence made unavoidable. Were there any underage girls at that party or at any party that Trump attended with Jeffrey Epstein? Bondi said this was ridiculous. She said they were trying to deflect from the great things Donald Trump had done. She said there is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. Her voice had a different quality in those sentences than it had when she was navigating the Andrew questions. Controlled, as it had been throughout. But the speed was different. The sentences came faster, more compressed, pushed through before Lieu could interrupt them. The body language is someone who has reached the question they prepared the most to not answer, and is delivering the prepared non-answer at the pace that prevents follow-up. Lieu said, I reclaim my time. I got your answer. You said there's no evidence. She said no evidence. He had a document. The document was from the FBI's own files. He said he was putting up another document, not another photograph, a document, a witness statement, filed with the FBI's National Threat Operations Center. The room went quiet in the specific way that rooms go quiet when a hearing transitions from a political argument to a piece of paper. The witness did not come to Congress. The witness called the FBI. The FBI had the statement. Nobody followed up. The statement was from a man who had driven Donald Trump in a limousine. He was in a professional capacity. A driver, present but peripheral, the kind of person whose presence is so mundane, it renders them effectively invisible to the people in the back seat. He was present when a phone call was made. He overheard what Trump said to Epstein. The statement described his reaction to what he heard, his anger rising to the point where he considered stopping the car. And it described a young woman he later encountered who told him what had been done to her by Donald Trump and Jeffrey Epstein. The statement also described what happened to that woman afterward. Her head was, according to the statement, later blown off. Officers at the scene, the statement described, concluded it could not have been a suicide. This witness called the FBI's National Threat Operations Center, not a tip line, not an anonymous reporting mechanism. The federal government's formal system for receiving information about threats and crimes from members of the public who have something to report. The witness filed a statement through that system. The statement is in the FBI's records. It has a date. It has a filing number. It is in the federal government's possession. Lieu read it into the record. Then he said, no one at the Department of Justice has interviewed this witness. The memo said no evidence existed. The witness called the FBI. Nobody called the witness back. That is the fact at the center of everything that followed in the next 60 seconds of the hearing, not the content of the witness statement, not what the limousine driver said he overheard, not what the young woman said had been done to her, but the documented absence of any investigative follow-up. A person called the FBI's National Threat Operations Center filed a statement. The statement described specific events involving specific people. The Department of Justice, whose memo stated it had not uncovered evidence that could predicate an investigation, had the statement in its files and had not interviewed the person who filed it. The statement is the evidence the memo said didn't exist. Or at minimum, the statement is the evidence whose existence makes the memo's claim that no predicate evidence was found a statement requiring explanation. Lieu said, I believe you just lied under oath. The hearing room held, not the theatrical pause of a proceeding performing accountability. The actual stillness of people processing a 7-word statement that carries a specific legal meaning when made in a federal hearing room by a sitting member of Congress to the sitting attorney general on the basis of a physical document. Perjury in a congressional hearing is a federal crime. Accusing someone of it is not done casually. Lieu said it, and he said it in that specific context. I believe you just lied under oath. And then he showed the document. Those 7 words were not a rhetorical escalation. They were a specific legal accusation made on the basis of a specific document in a specific evidentiary context. Bondi had stated there is no evidence. Lieu was holding a witness statement filed with the FBI that constituted evidence. The gap between the sworn statement and the document in his hands was the basis for the accusation. Bondi said, don't you ever accuse me of a crime. Lieu said, I believe you just lied under oath and this is all on videotape. You said there's no evidence of a crime. I'm showing you a witness statement who called into the FBI's Threat Operations Center. Let's examine that exchange carefully because the substance of what happened in it matters more than the temperature of it. Bondi's response, don't you ever accuse me of a crime, is not a denial. She didn't say, here is why the witness statement doesn't constitute evidence. She said, don't you ever. It is a warning. A denial would address the document. It would say that statement does not constitute the kind of evidence that predicated an investigation because of X, Y, or Z. It would engage with the legal question of what the statement establishes and why the DOJ's memo's conclusion remained accurate notwithstanding the statement's existence. A denial is an argument. A warning is a threat. Lieu made that distinction explicit. He said, I believe you just lied under oath. And he followed it with the document. The document is the argument. The warning in response to the document is the sound of someone who does not have the argument available. A denial would address the document. A warning addresses the person who showed it. The distinction matters because it documents what kind of response the document produced and what kind of response it did not produce. The warning and the document are now in the same permanent record next to each other, available to anyone who wants to understand what happened when Bondi said there was no evidence and Lieu held up a filing from the FBI's own system and said, "This is evidence." The limousine driver witness statement requires examination that the hearing room's time pressure prevented from fully occurring. Here is what the statement establishes as a matter of documentary record. A person called the FBI's National Threat Operations Center. That is a documented act. The person filed a statement. The statement is in the FBI's files. The statement describes specific events and specific people. The FBI received the statement. The DOJ, which issued a memo stating it had not uncovered evidence that could predicate an investigation, apparently did not interview the person who filed the statement. What the statement does not establish, standing alone, is that any of the specific events described in it occurred. Witness statements are evidence. They are not proof. A witness statement is the beginning of an investigation, not its conclusion. Whether what the limousine driver described is accurate requires investigation. The same investigation that Lieu was asking why had not been conducted. The DOJ's responsibility was not to take the statement as established fact. It was to investigate it, to contact the witness, to evaluate the statement's consistency with other evidence, to make a documented determination about what the statement added to the case. None of that happened. That is the documented fact. The statement exists in the FBI's files. The DOJ issued a memo saying there was no evidence to predicate an investigation. The person who filed the statement was never interviewed. Lieu told Bondi, "You need to interview this witness immediately." Then he said, "Epstein should rot in hell. So should the men who patronize this operation." And as we sit here today, there are over 1,000 sex trafficking victims, and you have not held a single man accountable. That number, over 1,000, is the documented count of survivors of Epstein's trafficking operation, not a political characterization, a count. The federal investigation produced it. The case produced it. Over 1,000 people who were trafficked through a network that has been investigated by the Department of Justice across multiple administrations, with the most significant conviction being Maxwell's, and with 0 prosecutions of the men identified as having used the network. The disproportion in that ratio, the scale of the documented harm against the scale of the legal accountability, is the context within which every decision about how to manage the Epstein investigation and its records has been made. Every DOJ memo stating there is insufficient evidence to predicate an investigation. Every photo redaction that shields the identity of individuals who are not victims. Every July 2025 closure of a case. Every filing in the FBI's Threat Operations Center that was never followed up on. Every hearing where the Attorney General has said there is no evidence while documents exist in federal files that constitute evidence. All of it exists in the context of 1,000 survivors and 0 prosecutions of the men who used the network to which those survivors were trafficked. The survivors were in that room, not metaphorically, physically present, seated in the gallery, watching every question and every answer. They had been in those seats before. They had sat in prior hearings and watched officials say there was no evidence. They had watched the July 2025 memo describe the closure of the investigation. They sat still when Lieu held up the photographs with the redacted faces, their own category of person in those photographs, and asked why the investigation had been closed. Their stillness was not passivity. It was the particular kind of attention that belongs to people for whom the words being exchanged in that room are not abstract. 1,000. 0. That is the ratio that Lieu placed in the permanent record before he said the sentence that ended his time. If you had any decency, you would resign right after this hearing concludes. That sentence is not a legal argument. It is not a procedural demand. It is a statement of moral judgment made in a federal hearing room, addressed to the Attorney General of the United States by a member of Congress who had just spent his time documenting a specific series of institutional failures. The photographs that constitute evidence, the memo that said there was no evidence, the witness statement in the FBI's files that constitutes evidence, the memo that said there was no evidence, and the 1,000 survivors against whom not a single man has been held legally accountable. The sentence stands in the record regardless of whether Bondi resigned. She did not resign. The hearing ended. Her time to respond was granted after Lieu's time expired, and the chairman gave her the floor. Her response addressed some of what Lieu had said. It did not address the witness statement. It did not explain why the person who called the FBI's National Threat Operations Center had not been interviewed. The statement is still in those files. The witness is still uncontacted. The 1,000 survivors are still waiting. And the 2 photographs that Lieu put on the screen, with the redacted faces establishing the presence of victims, with the named individuals standing next to them, establishing the presence of people the statute says may have committed crimes, are in the permanent congressional record. The photographs exist. The statement exists. The memo said no evidence. The photographs are evidence. The statement is evidence. The memo was issued while the statement was in the FBI's files, and the person who filed it had never been interviewed. That sequence is documented. The explanation for it is not. The investigation was closed. Someone should explain why.